I reject that. I reject that.
I know you do.
You're a corporate judge, and that's a corporate attorney, and I'm one of the private people of this country.
On February 6, 2026, a routine hearing in a Kansas courtroom took an unexpected turn when defendant Gary Michael Pelosa appeared via Zoom from the Butler County Detention Facility facing criminal charges in case number 26-CR25 and an extradition matter in case 26-MR19. Mr. Pelosa was represented by experienced defense attorney Darren Patterson, who had been appointed to handle his case. However, before the hearing could even begin, Attorney Patterson made a surprising announcement to the court. His client wanted to fire him and represent himself. According to Patterson, he had met with Pelosa multiple times, including overnight discussions in a breakout room, and Pelosa had made it abundantly clear that he wished to proceed without counsel, and what should have been a straightforward court appearance was about to become a lesson in the harsh realities of self-representation.
Mr. Patterson,
Judge, we have Mr. Pelosa at the seat.
All right, I'll call State of Kansas versus Gary Michael Pelosa. Case numbers 26-CR25 and 26-MR19. And actually, that's an extradition issue. So we'll take up 26-CR25 initially, and depending on how that gets resolved, then we'll proceed on to the extradition. So if counsel would state their appearances, please.
Gary Gear on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Gary Pelosa. Mr. Pelosa does appear from the Butler County Detention Facility. Judge, I do have an announcement to make. I have met with Mr. Pelosa. We've discussed his case. During that discussion, he did make it clear he wanted to represent himself rather than have counsel. We discussed that at length, as well as he has then thought about it longer overnight. So we've had a breakout room. We've discussed it again here today. And I can tell the court he does wish to represent himself and not have counsel. So based upon that, Judge, I'm asking the court to allow me withdraw.
Okay, Mr. Pelosa, is that accurate?
Yes, sir. I didn't know we weren't going to be in court today. I have motions here that I don't know how to get into court because the jail don't have mailing envelopes. I thought I was going to be in court so I can give it to your clerk, and I'm going to need to ask to push this maybe forward so I can find a way to get it into the court.
Well, Mr. Pelosa, what you're discussing is one of the complications of representing yourself. What's your educational background, sir?
I've got high school and two years of broadcasting school, and I graduated broadcasting school, so I had 14 years of school. And I had 2 years of business law.
All right. Why a person has a right to represent themselves. However, it is generally not considered to be a wise decision for most. Why is it you want to represent yourself as opposed to Mr. Patterson, who's an experienced attorney in this district? And
well, I'm going to tell you, I've advocated for prisoners in federal prison, and I have personally have gotten out 9 federal inmates myself. Also, in conjunction.
Well, generally, that's when somebody that's advocating for them, it's because they are a federal inmate of themselves. Is that correct? For you?
No. It's
okay.
Not correct for me.
The judge immediately began probing Mr. Pelosa's qualifications and reasoning for wanting to represent himself. This line of questioning was not mere curiosity, it was a constitutional requirement. Under the landmark 1975 Supreme Court case Ferretta versus California, criminal defendants have a Sixth Amendment right to represent themselves, but this right is not absolute. The court must conduct what's known as a Ferretta hearing to ensure the defendant's waiver of counsel is knowing, intelligent, and voluntary. The judge must determine whether the defendant understands the risks of self-representation and has sufficient competence to proceed without an attorney. Here, the judge asked about Pelosa's educational background to assess his general competency and ability to understand legal proceedings. Pelosa's response, high school, broadcasting school, and 2 years of business law, suggested he had some educational foundation, but notably, he had no formal legal training and was not a licensed attorney. The judge's question about why Pelosa wanted to represent himself, rather than use his experienced court-appointed attorney, was designed to ensure Pelosa understood he was giving up a significant advantage. When Pelosa mentioned his experience advocating for federal prisoners, the judge astutely asked if Pelosa himself had been a federal inmate, recognizing that jailhouse lawyers often gain their legal knowledge while incarcerated. Still, the judge let him proceed with his case despite clear indications he probably wouldn't do well. The judge's willingness to let Pelosa explain himself demonstrated judicial patience, but it was also the beginning of what would become a contentious hearing, as the judge began to realize exactly what kind of defendant he was dealing with.
So I'm just asking if I can get some time forward to get these documents into the court record.
Well, what's your experience in regards to filing motions and so forth?
I have a lot of experience in it, sir.
What is the nature of your motions at this juncture?
A notice in demand. It's really a notice in demand.
For?
I got evidence to bring forward, and no one's able to see. I mean, I wasn't even stopped. I was walking, but they said the registration.
Okay. Well, hold on.
I don't want to get into arguing anything.
Right.
So
now, do you understand what? Sometimes what I've done and other judges do is allow a person to represent themselves, but also have standby counsel available. Would you be receptive to that procedure?
no, sir.
Is there a particular reason why?
Right, because we haven't established the court's jurisdiction just yet. Sir, I'm one of the people, and I am the beneficiary for the defendant. You are a corporate judge, and that's a corporate attorney, and I'm one of the private people of this country. So I want to represent myself.
All right. Mr. Pelosa, are you going to be requesting a trial to a jury?
Yes, I will.
Is that one of your written motions that you have?
No.
Okay, in Kansas, on a misdemeanor, the law requires a person to file a written request for a jury trial. Again, on a misdemeanor offense, you're certainly entitled to that. But we set some earlier, and it looks like, well, we've got the next jury trial date is going to be February 25th. Are you going to be available and ready to go by that date? That's just a couple of weeks away, sir.
Well, I want discovery. I want the video of the officer's cam, and that's evidence in itself.
Well, and I understand that, and a certain amount of discovery is appropriate. Again, it's a lot easier.
The judge attempted to offer Mr. Pelosa a compromise that many courts use when dealing with self-represented defendants: standby counsel. Under this arrangement, Pelosa would represent himself as he desired, but Attorney Patterson would remain available to provide guidance if Pelosa encountered procedural difficulties or changed his mind about self-representation. This is a common practice designed to balance a defendant's constitutional right to self-representation with the court's interest in ensuring fair proceedings. However, Pelosa flatly rejected this offer, stating, "No, sir." When the judge asked why, Pelosa's answer revealed the true nature of his legal strategy, and it was one that immediately raised red flags. Pelosa declared, "Because we haven't established the court's jurisdiction just yet, sir. I'm one of the people, and I am the beneficiary for the defendant. You are a corporate judge, and that's a corporate attorney, and I'm one of the private people of this country." This language is classic sovereign citizen rhetoric. The sovereign citizen movement is a loosely organized group of individuals who believe they are not subject to government authority, including courts and laws. They often use pseudo-legal arguments involving terms like corporate judge, beneficiary, private people, and jurisdictional challenges. These arguments have been universally rejected by courts at every level of the American legal system and are considered frivolous. Under Kansas law, specifically KSA 22-3406, district courts have jurisdiction over all criminal cases, and a defendant's personal beliefs about the legitimacy of the court system are legally irrelevant. The judge, recognizing immediately what he was dealing with, chose not to engage with these arguments and instead moved on to practical procedural matters. He asked whether Pelosa would be requesting a jury trial, which is a right guaranteed by the Sixth Amendment for serious criminal offenses. In Kansas, under KSA 22-3405, defendants charged with misdemeanors must file a written demand for jury trial, and the judge made this requirement clear to Pelosa. The judge also highlighted a critical practical concern. The next available jury trial date was February 25th, just a couple of weeks away, and Pelosa would need to be ready to proceed by then. If he wasn't ready, the case would be pushed to April 8th, meaning Pelosa would remain in jail for months while awaiting trial.
Sir,
if you're okay, I'm going to set this matter for trial. The next date after February 28th is going to be in April the 8th at 9. So you could end up, remaining in jail for a good period of time. Is why I'm bringing these things up.
okay, I'm still challenging the court's jurisdiction. I can challenge jurisdiction at any time. I mean, sir, let me ask you this question. Are you a member of the bar in good standing?
I've been a practicing judge for the last over 5 years, sir, and yes.
Okay, is the prosecutor a member of the bar in good standing?
Okay, I'm not going to go playing your games here, sir.
Well, we have a conflict of interest.
Sir, I'm going to set this matter down for hearings. Jen, does Judge Webster, what's her next motions date?
Are you asking about a Monday misdemeanor control or a bench trial?
No, I'm not sure how she breaks that up. You tell me, I don't know the nature of all of his motions or how long that'll take, but it wouldn't be able to go on the expedited docket.
And Judge Webster would usually hear those on a Wednesday afternoon. That's when she has evidentiary type hearings.
Okay. Jen, can you look on that and see when she has next available?
The next available is going to be March 25th at 1:30.
March 25th at 1:30. So, Mr. Pelosa, at this time, I'm going to take your motion to represent yourself under advisement. I'm going to permit you to file your motions and not have Mr. Patterson do anything on that, but you need to get your motions on file. And that is one of the issues that, frankly, there's a lot of questions and I don't have those in front of me in regards to a pro se defendant. But we'll set that on that March 25th at 1:30? Jen?
That is correct, Your Honor.
Okay. That's when your motions will be set. You'll need to file those. You have them ready to go now, sir?
Yes.
Okay. I want those on file by March 5.
How do I get them to you?
Well, I'm not going to explain how you have to do things.
Okay.
You say you know how to do all this stuff. I cannot advise you how to proceed on your case.
I'm not asking for advisement.
Yeah, you are. You're asking for procedural questions in regards to how to do it, and the court can't hold your hand and do that. That's one of the extreme disadvantages of representing yourself.
The exchange that followed perfectly illustrated why self-representation is so dangerous, particularly for defendants in custody. Mr. Pelosa stated he had motions ready to file, but didn't know how to get them into the court record because the jail didn't have mailing envelopes. When the judge set a deadline of March 5th for filing these motions, Pelosa asked a seemingly simple question: "How do I get them to you?" The judge's response was blunt and revealing. "Well, I'm not going to explain how you have to do things. You say you know how to do all this stuff." When Pelosa protested that he wasn't asking for legal advice, the judge corrected him. "Yeah, you are. You're asking for procedural questions in regards to how to do it, and the court can't hold your hand and do that. That's one of the extreme disadvantages of representing yourself." This exchange highlights a fundamental principle of self-representation. The court cannot provide legal assistance to a pro se defendant. Under Canon 2 of the Kansas Code of Judicial Conduct, judges must maintain impartiality and avoid creating even the appearance of favoritism. If a judge provides procedural guidance to a self-represented defendant that goes beyond what is available to all parties, it could constitute improper assistance and create grounds for appeal. This is why judges often seem unsympathetic to pro se litigants struggling with basic procedural questions. They are legally prohibited from helping in ways that would compromise their neutrality. The judge's statement that "the court can't hold your hand" was not cruel. It was an accurate description of the legal reality. An attorney would know exactly how to file motions from jail. They would either mail them from their office, file them electronically through the court's e-filing system, or arrange for jail staff to facilitate the filing. But Pelosa, despite his claimed expertise in advocating for federal prisoners, apparently didn't know these basic procedures. This was precisely the kind of practical problem the judge had warned about when he questioned Pelosa's decision to proceed without counsel. The irony wasn't lost on anyone in the courtroom. Pelosa had confidently claimed he knew how to handle legal matters, yet he couldn't even figure out how to file a document. And that overconfidence was about to cost him everything.
So Judge will take those up at that time and make her decision in regards to Mr. Patterson, but I'm not going to require Mr. Patterson to do anything further on this matter. Mr. Patterson, would you be appearing on that docket as well?
Not normally, Judge, but I did put it down. If you are ordering that I continue as standby, at least for now, I put it down.
I would ask that you be there as standby right now.
I reject that. I reject that.
I know you do, and you'll get a full hearing on it. But today's not the day on that. That was not scheduled for today. So March the 25th at 1:30. That is in regards to 26 CR 25. All right. Moving on then to the 26 MR 19. Mr. Patterson, are you appointed on that case as well?
Because it is misdemeanor charges in Missouri, then yes, it does fall on my contract. But again, I've discussed that with him, and he has the same position on that too.
Is that correct, Mr. Pelosa?
Yes, sir.
You'll need to file your motions and things on that. We'll set it for March 25th at 1:30 as well. So I'm going to, Mr. Patterson will be standby counsel on that as well.
I reject that. If he wants to take the consequences of it, let him so. If not, then he needs to go.
He's not asking for that, sir. I'm ordering it. So at this time, and it's going to be the same order that I just made.
What's your authority?
You're still going to, sir, don't interrupt. You're still going to have the opportunity to do that. I'm not asking him to do anything on your behalf in the meantime, but you're going to need to file your motions, and that's going to be difficult from where you're sitting. So, file whatever motions that you feel is appropriate, and it'll get brought up at that time as well. Again, that's on Judge Webster's calendar. But if you're going to be requesting a jury trial on these matters, you need to get those on file as well, because that April 8th date is on the court docket coming up fairly soon. All right. Is there any other issues that we need to discuss concerning either of these cases for Mr. Pelosa? Mr. Regier?
Your Honor, if the court is continuing the bonds in both these matters, the state has nothing further.
Mr. Pelosa, anything further?
At this point.
The tension in the courtroom escalated when the judge made his ruling on the standby counsel issue. Despite Pelosa's repeated objections, the judge ordered Attorney Patterson to remain as standby counsel on both the criminal case and the extradition matter, despite Mr. Pelosa's refusal. This exchange demonstrated an important principle of criminal procedure. While defendants have a constitutional right to represent themselves, judges retain significant discretion to manage their courtrooms and protect the integrity of judicial proceedings. Under Kansas Supreme Court Rule 116, which governs the appointment of counsel for indigent defendants, courts have authority to appoint standby counsel even over a defendant's objection when the court determines it is necessary to ensure orderly proceedings. The appointment of standby counsel serves multiple purposes. First, it protects the defendant's rights by ensuring that trained legal assistance is immediately available if the defendant changes his mind or encounters insurmountable procedural difficulties. Second, it protects the integrity of the proceedings by preventing delays and ensuring the trial can proceed efficiently. Third, it creates a safeguard against later appeals claiming ineffective assistance of counsel or denial of the right to counsel. Notably, Pelosa's statement, "If he wants to take the consequences of it, let him so," revealed a misunderstanding of how standby counsel works. Pelosa seemed to believe that having an attorney present would somehow impose legal consequences on him, when in fact the opposite is true. The attorney's presence was designed to protect him from the consequences of his own legal ignorance. The judge's willingness to override Pelosa's objection and impose standby counsel demonstrated judicial wisdom born of experience. The judge had seen enough self-represented defendants struggle and fail to know that Pelosa was heading for disaster, and he was taking steps to minimize the damage while still respecting Pelosa's constitutional right to represent himself.
I'm going to continue the bond status as they currently are. Mr. Pelosa, if you do make bond, you are ordered to appear before the court on that March 25th date at 1:30. You're to be there at the courthouse. If it's a Zoom hearing, then they'll do it through court security, but you are to be present at that time. Do you understand?
What if I'm in another county extradited and I'm still in jail? So
that's another matter. I said if you were released, if you've made bond on your various cases, then and are released, that's the order. If you're in custody, typically these matters, you take care of the local matters here that you're charged with and deal with that. And then, before a person is extradited. But so that's going to make a complication for you perhaps, but that's your choice.
So if I may ask, the 26 CR 25 case, what is the 26 MR 19 case?
That's the extradition case.
Okay.
All right. It appears that on the 26 case, the bond is set at 10,000 cash assurity. So that'll continue to be the bond with the conditions that I just noted. Anything further concerning Mr. Pelosa?
Not from the state, Your Honor.
Very well. These matters are adjourned. Mr. Pelosa can be returned to lockup.
And as the hearing concluded, the judge laid out the path forward with crystal clarity. Mr. Pelosa's motions hearing was scheduled for March 25th at 1:30 p.m., giving him until March 5th to file his written motions, including his jury trial demand, which Kansas law required to be in writing for misdemeanor cases. The judge emphasized that if Pelosa made bond and was released, he was ordered to appear at the courthouse for the hearing, whether in person or via Zoom. Pelosa's bond remained set at $10,000 cash or surety, meaning he would need to either post $10,000 in cash or obtain a bail bond to secure his release. With a potential jury trial date of April 8th looming, Pelosa faced the very real prospect of sitting in jail for 2 months while he navigated the complex procedural requirements of criminal defense, all without the assistance of the trained attorney who had been trying to help him, and that lack of professional representation could prove to be a crucial mistake when the final hearing arrived. Mr. Pelosa's confidence in his abilities, based on his claimed success in helping federal prisoners and his 2 years of business law education, proved to be dangerously misplaced when faced with the actual mechanics of criminal procedure. He didn't know how to file basic court documents from jail. He rejected the safety net of standby counsel. He attempted to to use sovereign citizen arguments that have been rejected by every court in America, and he set himself up for a jury trial despite having no apparent understanding of trial procedure, rules of evidence, or courtroom advocacy. The judge's handling of this hearing demonstrated the delicate balance courts must strike when dealing with self-represented defendants. On one hand, the Constitution guarantees the right to self-representation, and courts must respect that right even when they know the defendant is making a terrible decision. On the other hand, judges have a responsibility to ensure fair proceedings and to protect defendants from the worst consequences of their own choices. By appointing standby counsel over Pelosa's objection, setting clear deadlines, and refusing to provide procedural advice that would compromise judicial neutrality, the judge walked this tightrope carefully. He gave Pelosa exactly what he claimed he wanted, the right to represent himself, while also creating safeguards to prevent a complete miscarriage of justice. The extradition complication added another layer of difficulty to Pelosa's situation. He faced not only the local Kansas criminal charges, but also an extradition matter to Missouri on separate misdemeanor charges. Typically, courts handle local charges first before extraditing defendants to other jurisdictions, but this meant Pelosa would need to resolve his Kansas case before being transferred to Missouri, or potentially sit in Kansas custody for months while both cases proceeded. His question to the judge, "What if I'm in another county or extradited and I'm still in jail?" revealed that he was beginning to grasp the complexity of his situation, but by that point, he had already committed to representing himself and rejected the attorney who could have helped him navigate these complications. Perhaps the most telling moment of the entire hearing was when Pelosa confidently claimed he had extensive experience in legal advocacy and knew how to handle criminal cases, only to immediately ask how to mail documents to the court from jail, a task any first-year law student or experienced criminal defendant would know how to accomplish. This gap between Pelosa's perception of his legal knowledge and the reality of his capabilities was emblematic of the Dunning-Kruger effect, where people with limited knowledge in a domain overestimate their competence. Pelosa had enough legal exposure to use terms like notice and demand and challenge jurisdiction, but not enough actual understanding to recognize that these sovereign citizen concepts have no legal validity and that his supposed expertise was insufficient to navigate even the most basic aspects of criminal procedure. As Mr. Pelosa was returned to lockup to await his March 25th hearing, one thing was certain. He was about to receive a very expensive education in why having a trained attorney is not just helpful, it's essential. Whether he would recognize this reality in time to accept the help of his standby counsel, or whether he would persist in his misguided belief that he could successfully represent himself, remained to be seen. But one thing the judge, the prosecutor, and anyone familiar with the legal system knew for certain: Gary Michael Pelosa was about to learn the hard way that confidence is no substitute for competence, and legal education from broadcasting school and jailhouse advocacy is no match for the formal training and experience of a licensed attorney. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.